All right. Well, thank you, those of you who are joining us live. We're here talking about why you shouldn't be caught dead without a will. And so I want to talk a little bit about the importance of having a will, particularly for those of you who own property. And so, my channel is all about landlording and, what landlords can do to improve their business. And part of that is, how they can set themselves up for success. And so for those of you who are joining us live, I want to answer your questions. Maricela, I see that you're there. You have yours already. Great. And so you can spread the good news to other property owners as to its importance, and you can speak to it from a personal basis. And hopefully together, we can figure out, well, what is the importance of a will? I've already got things set up in a certain way. Why do I need to, add anything at all to what I've already got? And so today I want to talk to you about the importance of a will, even if you've already made some plans. We certainly need to make plans about our property, and it doesn't make sense to own property and not have a plan. That's actually our first topic. But what if you've already done some stuff and you're thinking, I've got it in the bag. There's no good reason for me to have a will. We're going to talk about that as well. So for those of you who have not submitted questions, I've got 7 questions here that were given to me already from our Texas Landlords Facebook group. If you are coming up from Texas Landlords, hello, feel free to say hi in the chat. We love hearing from all of our people, but any questions that may pop up in the middle of this, please let me know. I'm happy to answer those, and I'll keep a close eye on any new questions that pop up. But for now, let's go ahead and get started. One thing a technical issue I want to address. At some point, somebody mentioned that there was a scratchiness in the sound. If anybody's experiencing any kind of scratchiness or any kind of hiss, let me know. I want to know so I can adjust anything necessary to do that. But if the sound is okay, give me a thumbs up so that I know that everything is good. Because again, I want to make sure that everybody can hear me properly. If there's anything I can fix, let me know. But I'm about to jump right in. So a plan. It is absolutely essential once you own property to have some sort of plan, because if you're hoping that the discussions that you've had with your family are enough, I guarantee you they are not. Unfortunately, sometimes we have discussions and you don't die for many years. And so your mind changes. The people that you had in place or in mind for those discussions have changed. So much changes over time that unless it's somehow etched in stone, those ideas probably will not be preserved. Again, just because you had it up here and you shared it with somebody doesn't mean they remember accurately what you meant in terms of how your property should be handled. And so, if that's the case for you, passing away without a plan is going to be detrimental to you and your estate and your family. So definitely, if you are a property owner, get a plan in place. Some kind of plan is absolutely necessary. Today, I'm advocating a will because in many states, it's very easy to draft up a will. You don't actually need an attorney. You might want to talk to an attorney so you get some guidance and kind of figure out what works best for you. But really, wills are not super complicated, and there's stuff out there that'll help you draft at least something basic so that you don't pass without some kind of plan. Because leaving everything to your family to sort to way too complicated. If you left without a plan and now your kids or your spouse are having to figure out what to do with the property That's a lot of stress. And a lot of the fights that we see in terms of litigation after the passing of a loved one is as to who actually has control. I've had situations where you have 7 siblings, mom and dad are gone, they left no plan, and 6 of them are on board, and one of them just is not. And that one sibling can cause the whole thing to be in turmoil because they can't lease it, they can't sell it. That sibling wants to live there and doesn't want to pay anything. Everybody else is paying their fair share except for that one holdout. And guess what? There's not a lot in terms of authority that those other 6 siblings can do. So don't leave them out in the cold. Because again, sometimes there's a family member who will simply take advantage of the situation. It happens all the time. You don't intend it to happen, but it does. And so you don't want the family members that you did intend to benefit from your property to lose out on that benefit because of a family member who takes advantage of the situation when you've left no plan. Well, let's say you do have a will, and that's very good, but somehow you die without it. Ernie, how is that even the case? If you've got a will, doesn't that mean everything's taken care of? Not always, because if you don't preserve that will, there's nothing to prove up. There's nothing to follow once you do pass away. If you keep it in the basement or if you keep it in a room, you just keep it in a cardboard box and you live in Texas, you're just asking for a flood because it happens a lot. Some kind of natural disaster comes through and your paper document, if not preserved, can be destroyed. And so weather does this, water does this, just kind of not being careful with our documents. You want to put your will in a fire safe, in a fireproof safe. That's absolute. And if you don't have one, you want to find one. Another thing that happens, it's not always just that, grandpa, didn't write a will. He wrote a will. And it's not that grandpa didn't have a fireproof safe. He had a fireproof safe. But grandpa was also very secretive. And no one knew the combination to the safe, or no one else had a key to it to unlock the safe, or nobody knows where that safe is. We know of it, but we don't know where it actually is. And when this happens, it's like dying without a will because no one can track it down. And so it is helpful if you do have a will to have people in your inner circle who are close by, who can, point people in the right direction so that will can actually be probated. It doesn't make sense to have something that nobody can execute. So if you've got it written down, if you actually went through and got a plan, tell at least your executor or your executrix where it is. Another good rule of thumb, give them a photocopy of it. Let them have a preserved copy so that if in the event you have loss through a fire or a flood or some other loss, at least there is a document out there that can be used in some way to follow your wishes. So find somebody you trust, get them a copy of your will so that in the event of destruction, you've got at least one backup. So protect it, tell people about it, and duplicate it. So you need a plan. If you got a plan, preserve the plan. The last thing that I want to talk about on this is, let's say you are that smart cookie and you've heard my last talk on a transfer on death deed. You say, Ernie, I own 1 or 2 properties and I've already set up transfers on death deeds. When I pass away, boom, done. No probate needed. My kids or my spouse or my fill in the blank, well taken care of, not gonna be a problem. Or you say, Ernie, I've got 15 properties, or I've got an apartment complex, or I've got X, Y, or Z in a trust. It's all set up, and my trustee is gonna take care of everything. Or I've got a series LLC or a corporation or a limited partnership that already has control of all of my rental properties. Why the heck would I need a will? It's for the stuff that's not held by any of those documents, not your transfer on death deed or your trust or your corporation or your LLC. None of these have certain bits of things that are still important to you. Now let's talk about what might not be a probate asset. So certainly if you have accounts, your 401k, anything that you can have, your insurance proceeds, anything that could have a beneficiary designation, no need whatsoever to include in a will, because that stuff is already controlled by the document, right? So if you had an insurance policy and you had beneficiaries named in it, again, you definitely want someone who has access to that insurance policy so that it can be paid out upon your death. But that money isn't controlled by your will. It's also not controlled by your trust, and it's not in your transfer on death deed. It's controlled by the document itself. And so that insurance policy and its beneficiary designations are controlling. But there's certain things that are not, like your vehicles, your cash on hand. Maybe you own art. Maybe you own really expensive furniture. Maybe you have something else that's special to you. Maybe it's your wedding ring and you want a specific individual to have it. Maybe it's the family Bible or some other important item that is yours that you promised to a specific individual. Just because you promised it to them doesn't mean they'll actually get it if you have not laid that out in some kind of enforceable document. And that's where the will steps in. So your trust or your LLC or your transfer on death deed, again, those are great for real property, but not so great for personal property, like your vehicles and other things of value. And this is where your will can step in. Right, so in your will, you can designate individual items to individual people, but the beauty of the will is the catch-all. Because you're right, you might have the most important stuff already taken care of in some other fashion, but the catch-all is where your will might really save the day. Let's say, for example, you acquired property later in life that you never got to transfer into your trust, or that was not transferred into your LLC, or that you didn't file your transfer on death deed soon enough. If you've got a will in place with a catch-all provision, that is to say, anything not distributed above, all of the residual or the residue of my estate shall go to X. You're done. You've got it. You've taken care of your stuff and passed to somebody you love or somebody that you trust with that stuff because you've got a will with a catch-all provision that after you have died, anything that otherwise was not planned for, or maybe it was planned for and the beneficiary passed away, or some other issue prevents them from taking it, your catch-all provision kicks in, and the benefit of your will is you have accounted for it, even if you couldn't account for it at the time of your death, right? Perhaps it was a mistake, or perhaps, again, someone predeceased you or died alongside with you. This happens sometimes, and so they cannot accept it. That catch-all provision steps in and distributes your property to somebody you love or somebody you trust in accordance with your wishes. So I like advocating for wills, not because I think it's the only method that you should utilize to protect your property and make sure that your stuff gets where you want it to get, but because it is just another tool that you can use to make sure that your estate is handled in accordance to your wishes. Again, whether you own one property or 1,000 properties, you want to make sure that your wishes are honored. The best way to do it is with, again, multiple tools. And one clean tool to have is a will, because it might catch some of the stuff that falls through the cracks. So I hope this was helpful to you. I'm getting a couple of comments popping on. Hello, Olga. Let's see, Kimberly, are there any requirements on who has to know about a will that's written? Any specifics on keeping them private? Well, naturally, these things are private. Your attorney, for example, is someone who can keep a copy of it, maybe even hold on to the original. That's going to depend on your attorney. Some attorneys do hold on and preserve documents in fireproof safes for that. For that purpose. Our office does not do that, but you may find an attorney that does that on a regular basis, and then upon your death can be contacted to share the details with the family, particularly the executor or the executrix. But no, there really aren't rules as to who can know and who shouldn't know, or who must know. That's entirely up to you. And so if you want to tell one other person, that's okay. If you want to tell 10 people, that's okay too. But in terms of who has the original copy, that's a very private decision. But again, if you die and you're the only one who knows where it is, it's a problem. You want to make sure that somebody can always locate the original will. That's the best document for this kind of transaction. And if you don't have at least one person you can trust, you may need to seek out the help of a professional. I'll tell you one thing that sometimes people do that can be problematic is if they leave their will in a safety deposit box in a bank. Well, if you're the only one who has access to that safety deposit box, it's the same problem. You would need to get someone to have some kind of authority from a court, like letters testamentary or letters of administration, to access that box just to find out if there is a will or what's in the will. And so again, you're kind of giving multiple hoops to your family that otherwise would not be necessary. So sometimes the safety deposit box isn't the best place to keep a document, especially if nobody else has access to it. So think about these things before it becomes necessary. Think of these ahead of time. That's why we're talking about them today. Thank you, Kimberly, for that question. Anybody else with a question, please feel free to add it in the chat. But I'm going to go into the 7 questions that I was given at the start of today's talk. Number 1, Ernie, isn't a trust better than a will? Well, we covered some of that in my presentation. Better isn't the word that I would use. It's different. It does different things. So your probate assets would be those things that are not already part of something like a trust. They're not already cared for. They're not already designated, like maybe insurance proceeds, or maybe even your bank account has a payable upon death beneficiary on it. And so you don't worry about that. But what about your gun collection, right? That's probably not already in your trust. It could be, but if it's not, and you wanted your guns to go to a very specific individual, but you never designated that in any enforceable way. If that's the case, the person that you wanted to have them the most may never get that opportunity. So is a trust better? It's better at doing certain things. It's certainly better at leaving someone in charge of property to follow whatever the trust rules are, whatever the trust directives are, but it doesn't always catch it certainly doesn't catch anything that was left outside of the trust. So in that way, they're both good together. Number 2, I allowed an itemized deduction for security deposit. Oh, so this is a non-will question, and that's okay. I allowed an itemized deduction for security deposit summary to the tenant. Allowed to claim the $50 for first violations, $100 for second, same administrative violation fee, it states in my lease. Just to mention a few, they moved people in without authorization, had cats without authorization, fire and safety hazard violation, parking on my grass, and neighbors. Oh, I think they meant, am I allowed? Yeah, I'd have to read precisely what's written in your lease to accurately answer this question, because sometimes the way you say something makes it unenforceable. But if you have actual damage caused by these situations, yes, you can always charge for actual damage that was incurred, and you can deduct from the security deposit in accordance with your lease and with state law. Now, in Texas, and this is the case in most states, you can't deduct for normal wear and tear. So if your claim is these damages exceeded normal wear and tear, well, you got to be able to prove that. And if you can't prove what the original condition was and the condition after your tenant's use was, you may be unable to prove damage at all. But remember, there might be a gray area as to what is normal and what is in excess of normal wear. So that's its own thing. And I'm not going to get too deep into that. I talk about that in numerous other videos. But as far as administrative fees, you better be able to prove with some administrative fee that the cost goes to some real thing. So one administrative fee that sometimes is in leases is a fee to issue a notice to vacate or a notice of default. And so let's say you're issuing notices as default and your lease allows you a $50 processing fee. And that includes you taking the time to draft the notice and then mailing that notice through regular and certified mail. Maybe you send it through FedEx or UPS. And so there are legitimate costs involved that you can demonstrate to a court. As opposed to, well, I send all my notices by email and here we go, you are in default. Nope, send. I don't know that you can justify that as worth $50. And so if you have to convince a court that an 8-word email is worth $50, you're probably going to be on the wrong side of that argument. However, you can demonstrate to a court that the fee is reasonably related to the thing that you did administratively, then yes, I think you're okay. It shouldn't be a stretch. It shouldn't be an eye roll kind of, I don't know, it doesn't make sense to me. You always want it to make reasonable sense. And so actual harm, yes. Actual administrative costs, yes. Speculative harm, speculative administrative fees, not so much. Let's move on. Okay, we got a default judgment for eviction on a tenant who hasn't paid rent since October. Great. He didn't show up last week at court. That happens all the time. He seems to be appealing it and saying he can't pay. We just paid to file the writ too. Okay. How likely is he to win on appeal? I don't know. The guy we hired to do the eviction says he's a professional tenant, and I agree. He's a criminal and knows tricks to game the system. Well, sounds like you hired someone to help you with the eviction. I don't know if this is an attorney or not. And so if it's an attorney, I can't give you legal advice. That violates my code of ethics. But speaking generally, sometimes people appeal because they have a valid defense. But in Texas, anybody can appeal any eviction at least once. And you don't need a defense. It goes up on appeal so that a second judge can hear the facts and maybe make a ruling. So why he appealed, couldn't tell you. Whether he's got a good defense, couldn't tell you. Because sometimes a tenant who has failed to pay rent has a procedural defense against you. And so I don't know enough about your case to know whether or not you issued your notice properly, you waited the requisite number of days, you mentioned all the right defendants in your litigation, or some other necessary part of your eviction that procedurally is in error. I don't know. Could be. And it could be that he raises this for the first time on appeal on that second level. If we're talking about the state of Texas, that jumps from the justice court up to the county court. And if for the first time in the county court, he raises a valid defense that he could have raised below, guess what? It's just as valid on appeal for the very first time. So could he win? Maybe. If you've got legal assistants helping you, make sure you run through this with them. But again, if you've got legal counsel, I can't help you. If the assistant or the person who was assisting you with this is a non-attorney and you need someone on the appeal level, feel free to give us a call. Okay, number 4, and we're getting some responses here. Kimberly says, thank you. Oh, you're welcome. How often have you seen a jury overturn a legal will? Now, that's a great question. I'm not a probate attorney. And while I can answer questions about wills, and we even draft wills, we don't actually litigate wills. And so that's not something that I've ever done. And so I don't have personal knowledge on juries overturning wills. Juan says, thank you for the, oh, you're very welcome, Juan. Thanks for watching. Thanks for joining us. So, Kimberly, sorry I couldn't go much deeper than that. But if in the future I do get that, I'll be happy to share it. But for now, I just don't know. Number 4, with 5 rental properties, is it wise to create an LLC? Does it give any tax advantage? Was told by my CPA not worth it. Well, I'm not a tax attorney, nor am I a CPA, so I can't tell you whether there's value in terms of a tax advantage. My perspective is different from that of a CPA and different from that of a tax attorney, because I'm thinking about litigation. And so is it worth it to have an LLC for all 5 properties? Maybe. And so let's say you own your own individual house in your own name, and you have an LLC that owns the other 5 properties. Well, you've shielded your personal assets from your business assets. So should anything go wrong on the business side, your personal assets, A-okay, no problem. The issue then is, well, what's shielding my properties from each other? And that's actually a significant threat. So there are 2 ways to deal with this. Either A, you get 5 individual LLCs, or B, you construct a series LLC. And in your series, one of the series for each of your properties can hold title and still maintain protection for you from your shielded from your individual stuff, but then protection from each other. And so if you're asking, well, what's the value of it? It's not so much a tax value, but it is a liability value. And so you want to defend your properties from each other and from you. An LLC for a single property, multiple LLCs, or a series LLC would be an adequate way to shield them from you and from each other. So I hope that answers your questions. Let us move on. Number 5, how do I transfer property from me to a trust or LLC? Is a trust or LLC better? They are different. So with an LLC, it's really just changing the name from one party to another. You can still maintain full ownership and control as long as you are a member of the LLC. With a trust, you are transferring title, very much like to an LLC, to a trustee. And that trustee takes title and takes instruction from the trust itself. And so the next thing that an LLC doesn't necessarily have is a trust document. And in that trust document, the trustee has instructions on how to manage the portfolio held within that trust. There are 3 parts of a trust, and this is not a trust discussion, so I'm not going to get too deep into this. There are 3 components to a trust: the maker or the creator of the trust, the trustee, and the beneficiary. These are 3 distinct roles. You can serve in multiple of those roles. How you do that is going to determine quite a bit as to how your trust is managed. We can maybe do something more about trusts in the future, but for now, they are different. And so depending on various factors, the LLC is quick and easy, very simple to set up, and very easy to maintain. The trust is slightly more complicated, and it actually has a little more anonymity than the LLC does. So there are pros and cons to both, but they are different. But they're also both quite excellent at shielding you from individual liability and for having a method of maintaining ownership even after you die. Now, with the trust and the trustee, you have a beneficiary designations that will likely survive you. With the LLC, it's a little bit different because the LLC will never die. But if you're the sole member of that LLC and you die, well, then you've got a problem because now the LLC is there without a single member and probably has to be dissolved along with your estate. But if you and another party are members, you have a partnership agreement that can handle what happens when one person dies. Does the other person take full control? Do they have the ability to add other members? Again, we're not going to go so deep. I feel like I've gone on and on and on about this, but there are differences and pros and cons to both. But they're both excellent mechanisms for dealing with your property, again, even beyond your lifetime. So let me move on to number 6. Earlier, I had a question about 2 people who were on our lease who decided to move out early in October. And the lease doesn't end until June of 2025. They were both on the lease, and he just died last week. Does anything change on our end? She's still paying the lease, but wants out. We are trying to find a new tenant. She claims mental abuse from him, and that's why she's not living there anymore, even though he moved out months before she moved out. This seems like a much more complicated fact pattern. But here's the thing. They're both still obligated on the lease. And you're asking, Ernie, the dude's dead. Well, he may be dead, but his estate is still around. And so his estate can be probated for the next 4 years, as can its debts. So I don't know if he owned anything of consequence. I don't know if he had any accounts or any issues, but if there's a debt that's attributable to him and his estate, it's still technically collectible. Now, I don't know what's going to happen between now and June of 2025, but it is possible that she continues to pay all the way through the end if you don't find another tenant. Here's another possibility. Let's say she's paid through the month of February, and wouldn't you know it, next month or before February ends, you get a tenant in on March 1st. Well, you've just mitigated your damages. And if the only damage you were experiencing was unpaid rent and she paid up through the month of March, your damage calculation now with a new tenant in place is 0. And so you're made whole, she's fine, even if she doesn't pay another penny. The fact that you found a source of mitigation helps everybody out. And the truth is the law requires that of you. Once you know that they're out and they've abandoned the lease, you have a duty to mitigate your damage. You can't just lay back on your laurels and just assume she's still obligated. You have a duty to find a new tenant. Once you do, your damage calculation is terminated. Number 7, an outside water pipe bursts. The tenant notices 3 weeks later. Ouch. And then notifies me. Next day it gets fixed. Who is responsible for the high water bill? $360. So who has a duty to maintain the property? Chances are very high it's a duty of the tenant. I don't know what your lease says. So step 1, examine your lease. If a pipe burst, does he have a duty to promptly report repair issues to you? Is there some reason why this duty doesn't kick in? Couldn't tell you. But let's assume all things being equal, does he have a duty to check the perimeter of the house, the inside of the house? Probably. Again, your lease will say who has a duty to maintain the property and to report any issues like this that require repair. The fact that he didn't report it timely probably means, again, I haven't read your lease, but probably means he has some liability. Is it reasonable to charge him everything? Probably not. And so I would discuss this with him and say, look, I don't want to fight you. If you're willing to pay X, I'll cover Y, and we can call it a day. But the idea that you don't owe something just ain't true. And so I would say, again, assuming your lease is direct as to who is in charge of maintenance. Because if it says the landlord assumes all maintenance of the property, well, guess what? You maybe can't pin this on them. If you're the one who has exclusive duty to maintain the property and he has none, and most leases don't say that. But I mean, if for some reason you pigeonhole yourself into there, that could be a problem. So look at your lease. What does the lease say about maintenance and reporting repair issues and the diligence that the tenant needs to exercise in order to do it? Do that, then talk to your tenant about resolving this matter. Well, I appreciate all of you who have stuck it all the way through till the end. I don't see any other questions here. I've answered all of the questions that I had here. I hope you guys benefited from today's talk. And as you know, are there any clauses you would put in a will? Well, Kimberly just jumped on and said, are there any clauses you would put in a will? Well, that's a very general question. I mean, absolutely. There are clauses I would put in a will. I know the clauses that I enter into a will. I'd have to see what a will looks like to see if it needs any of those clauses. There are certain basic ones, absolutely. They go in most wills, but every state's a little different. That might require a deeper dive. To keep it from being overturned if contested. Yeah, so in terms of that, there's one really great thing in Texas that, again, very likely is available in many other states. I don't know, Kimberly, if you're in Texas, but a will can have a self-proving affidavit. And so one thing that I think is crucial in Texas wills is that self-proving affidavit. And what it says is, look, we not only witnessed the testator signing his will, we're going to swear an oath that we witnessed that. Boom. And so now the issue of whether or not it's a valid will has a much stronger backing because you have that self-proving affidavit that essentially says, by virtue of this affidavit, we know that the testator signed, we know that the witnesses were actually there, because on top of that, they had this oath notarized at the time of signing. So I hope that helps. That's definitely one thing in Texas that is available to just bolster the validity of a will. Lucy just jumped on. Property has mother and daughter's name, no will, no transfer on death deed. Deed has both names, doesn't say joint tenancy or right of survivorship. What happens if one passes? No if. We're having today's talk because one, in fact, both will pass. So what happens when one passes? Does the other have full ownership still? No. So the easy answer is if you have two co-owners, right, and one passes away, if they pass away without a will or without a transfer on death deed, then they pass away intestate. That means no will, no designation. So in Texas, intestate designation means you got to follow the standard heirship as per the law. So let's take mom first. I'm assuming that dad isn't in the picture or that mom is unmarried. So if mom is unmarried and has one daughter, well, intestate distribution says if mom dies first and there is no spouse and she only has one child, and that child's already here, then yeah, it goes automatically to that one child. If there are multiple children, then it gets distributed in equal parts. So let's say, for the sake of argument, mom, one child on the deed and one additional child not mentioned in the deed. Guess what? Mom's share goes half to that child, half to this child. So now this child who's on the deed is 75% owner, and the other child has a 25% ownership. So I'm not going to get too deep on this, especially once we start talking about math. People go crazy. But it's not automatic. Without a right of survivorship, which would make it automatic to the surviving member, it goes through intestate distribution, and it's going to depend on the rules of your state as to how that goes. Generally in Texas, and I did a video about this before. In fact, just on Monday, you can check that out. And I described the general. It's usually from spouse to spouse, or from remaining spouse or remaining parent to children. After that, it gets kind of wonky, and I don't want to get too deep into it. But no, it's not automatic that it would go from mom to daughter just because they are both on the deed. It would depend on other factors. Kimberly says, I appreciate. Oh, thank you. I appreciate that. And I appreciate all of you who joined and all of you who contributed questions. I'm going to go ahead and wrap things up at this point. I thank you all for showing up. I love doing these talks. I will do them consistently every Wednesday on a different topic. Next Wednesday, for example, we are talking about defaults. We're going to get into what it means to manage property in a way that really raises your games, because every tenant defaults. And the question is, how many defaults is it going to take before you act? My philosophy, just one. And if you follow that philosophy, I promise you your property management is going to be significantly better. So I hope to see you next week when we talk about defaults. But until then, landlords, happy leasing.